Oh. I'm going to call this meeting of the Ocean Township Planning Board to order. Nicole, can we please have a roll call?
Of course. Councilwoman Kaplan?
Here.
Ms. Valente?
Here.
Mr. Beal?
Here.
Mr. Edis?
Here.
Mr. Manel? Mr. Bogdanovich? Mr. Mamie?
Here.
Mr. Goslin?
Here.
Vice Chairman Paludas? And Chairman DeFilia?
Here.
And then I forgot Amir because he's at the very bottom. So Amir, Berkowitz?
All right, salute to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Great. The notice requirements of the Open Public Meeting Law for this meeting have been satisfied. A copy of the notice having been sent to the Asbury Park Press and the Coaster and filed in the office of the Township Clerk. There is an emergency exit through the courtroom doors and 2 exits in the rear of this room. There is no smoking. That includes vaping. Board policy is that no new cases will be started after 10 p.m. and no new testimony taken after 10:30 p.m. In addition, the applicant will be limited to 45 minutes of testimony. Please note, all meetings will be video and audio taped and shown on the Township of Ocean's community cable channel, Channel 22 on Verizon Fios, and Channel 77 on Cablevision. All cell phones must be turned off, and if you need to make a call, please make your call outside the meeting room. All right, first order of business, we have some minutes that need to be approved. We need to take these one at a time. So before we start, does anyone have any questions, comments, concerns about the minutes? All right, so let's start. Do I have a motion to accept the January 27th, 2025 minutes?
I'll make a motion.
Moved by Ms. Kaplan.
I was absent.
I have a second.
Am I on that? We're good.
Seconded by Mr. Beal. All in favor?
Aye.
Aye. All right, motion for the February 24th, 2025 meeting minutes. Moved by Mr. Mamie. Do I have a second?
I'll second.
Seconded by Ms. Kaplan. All in favor? Aye. All right, March 24th, 2025. Do I have a motion?
I'm gonna make a motion.
Oh, I think Julia beat you.
Okay, got it.
Seconded by
Being second's just fine.
Mr. Beal. All in favor? Aye. November 11th, 2022. If you'll just please note, these were minutes that were never finalized, that we are just wrapping up. So I will make that motion since I was there. Do I have a second? I'll second. Seconded by Mr. Adis. All in favor? Aye. All right. We have no new business this evening, but we do have old business, and we will be moving along to our redevelopment investigation for Block 34, Lot 11 on the Township's tax map and commonly known as 1610 Highway 35 in Ocean Township, as to whether all or a portion of the area hereinafter described meets the criteria for an area in need of redevelopment pursuant to NJSA 40A:12A-5 and should be designated as such. And I think where we left it, Topology had just finished presenting.
Correct.
And the owner's attorney had requested time to review. So if you'd like to come up and share your comments, and then I believe we're going to have an opportunity to cross-examine the...
That's correct.
Great. If you can just please remind us of your name and where you're from, and we'll get rolling.
Thank you. Mr. Chair, members of the board, Anthony Todaro of Fakery Drinker, Bidwell & Reeve, on behalf of the property owner, CJ Realty LLC. Just as a quick housekeeping matter, we did submit not only our formal notice of appearance, but also wanted to advise the board that the property has recently signed up a contract. We're going to sell it to a third interested party. We requested just a brief adjournment of the area needs study from tonight because we have a quick closing date. We want to at least afford an opportunity for the new property owner, post-closing obviously, to be able to sit down with the township, actually engage in the redevelopment process. I'm assuming your attorney's going to advise you that, look, we're here tonight. There's no statutory basis for a further adjournment. But what, Chair, I believe is you, and also Mr. Averson mentioned himself, that this initial process in the redevelopment step it's the initial step. I want to make sure you get it right. they don't want to have any cracks in the foundation, I believe he said. And so, apart from any issues we might raise tonight to the report itself, there is still an area in need of redevelopment with condemnation tag associated with it. Our German request was signed on by the contract purchaser, saying, look, we're going to want to speak with the township directly. We have an issue with that condemnation portion. If the board were to continue tonight, make that recommendation, you might have to you might be taking one step forward, but you're going to take at least 2 steps back.
Mr. Lexington, please remind me, that's not within our purview to decide, though. Our purview is to decide whether or not this area in need of redevelopment at the time that the study was conducted meets the criteria, correct?
That's correct. You're not making the designation.
Yeah, that would,
So if they want to have any conversations with the township council, they're more than welcome to, because the township council is the one who's going to be actually making the designation, not this board.
correct.
So my recommendation is, I don't think you should delay based on the fact that they signed the contract. It doesn't make any sense to me personally. You are still under directive by the mayor and council to evaluate the study. That's not going to change whether they're in a contract today, whether they're in a contract 2 months from now, or whatever the case may be. It's still going to be the same property. If they want to talk to the council, they can talk to the council.
And that's fair. However, what we're saying is, look, the board were ultimately decide to make the recommendation that the property constitute an area in need of redevelopment with condemnation. That latter portion is something that would need to be revisited in the future. So a brief pause, in our view, whatever negative impacts, which we don't see there being any, are dwarfed by the need to then have to come back in and reopen this initial step of the redevelopment process. So that's what we submitted. Understand when it's well taken, but we just want to make that note.
Well, from my standpoint, I think that's for the council to decide, not for us. We have a very specific task statutorily to complete, and we're going to do that unless any of my fellow board members want to have a discussion on it. Hearing none, we're gonna move forward.
Fair enough, thank you.
Mhm.
And then I believe what we would probably want to start out with is cross-examining of your planning consultant.
Come on up.
One question, I guess, for Mr. Lexington, I'm sorry. Would it be appropriate to have Ms. Spire, who worked with me on the report, join me up here?
Yeah, I don't have a problem with that.
And we just need to have her sworn, right?
Yeah, that's fine.
Seats are like tied together. Your chair.
I have to.
Yeah, you should be able to do one of those, you know?
They're all at the same time.
Oh, they literally are tied together. I thought he was kidding. That's different. Keep people from fighting and throwing chairs at the panel.
Thank you for accommodating us. I'm still under oath.
Yeah, let's just, I'll swear you in. Do you swear testimony you're about to give will be the truth, whole truth, and the truth, help you God?
I do.
Thank you. And just state your full name for the record.
Golda Spire,
Thank you.
and I'm sorry, what's the purpose of both of you being up here?
Ms. Spire worked with me on the report, and I just wanted to make sure that we had her knowledge here as well.
Okay, so if I'm going to cross-examine you on your own testimony without the need for any support from another planner, I don't necessarily think it's appropriate for both of you to be up here to buttress your own testimony if we're just going to ask you some follow-up questions on it.
Are you cross-examining him on his testimony or on the findings in the report?
Well, a little bit of both here, but if he's the one who testified to it, I'm not sure why we need to necessarily supplement it without further direct testimony from another planner.
I mean, look,
Well, she's-
I don't want to complicate it. If he has questions just for Phil, just ask Phil. Golda, don't jump in, and if Phil says he doesn't know something, then we can handle it that way. Is that fair?
Yeah, we could take it as it comes, but
this is-
it's just slightly unorthodox.
So this isn't okay. So this isn't a federal murder case.
I
Okay,
understand
it's a report. So if you have questions about something that's in the report, that he doesn't know the answer to, I don't think it's outrageous to then turn to her and have her answer the question if she happens to know the answer, because he just doesn't happen to know the answer. I mean, it's not like, haha, you didn't know the answer to that, so therefore your testimony is irrelevant. We're talking about a specific report, and that's what you're asking questions for. It's not a gotcha game.
Correct.
So-
There's no gotcha.
No, I understand that, so
But
I don't know what the objection would be for her to be there. But I agree with you in general, depending on the question, that it's not appropriate for her to answer a question if it's specific about his testimony. But if he doesn't know the answer, he should be able to say, I don't know, I want to defer to her.
In terms of process, sorry to interrupt, can we just do one and then the other? If you say you don't know, then you can,
That's fine too.
Defer.
It doesn't make a difference to me, but I don't think it's that big of a deal.
As long as the record doesn't get muddy, that's all.
I don't
If
think
he's
it will.
answering, because,
Yeah.
I mean, look, at the end of the day, the board was gonna rely on the direct testimony being proffered. Now we're asking questions.
100%. And I don't think it's going to get messed up. I have a feeling her voice is very different than his voice. So I don't think anyone's going to have a problem differentiating between the two.
And we'll make sure to announce ourselves if we change speaker.
Okay.
All right. Mr. Anderson, how are you doing tonight?
I'm fine, thank you.
All right. And so you introduced a report dated March 7th, 2025, is that correct?
I'll take your, yes,
All right. And then you provided direct testimony during the May 19th, 2025 meeting, correct?
I'll take your word on the date, yes.
Okay. And so that was the date of the last planning board meeting. I believe there was a little colloquy with with the board as to some changes to the report. Do you recall that?
I do.
All right. And were any of those changes made to the report?
No,
And so, is it fair to say that the entirety of the blight designation is your direct testimony and the report as of March 7th, 2025?
that's the evidence on record, yes.
Okay. And so, let's get into that, because what you testified to the board at the last meeting on May 19th is that it's your opinion that the property constitutes an area in need of redevelopment based off of criteria B, D, and H, correct?
Yes.
All right, and so, flipping first over to, why don't we flip to page 14 of your report. But you know what, before we get into anything specific, did you prepare the March 7th, 2025 report?
I oversaw the production of the report in coordination with Gold Aspire and others on my staff.
All right, and do you mind if we just, for like simplicity purposes, you want to call it the area needs report, whatever you feel comfortable with?
Whatever you feel
Area
comfortable
needs
with.
report, fine. All right, and so, did you actually visit the site?
Yes.
You did? When did you visit the site?
I don't know the date.
Okay, but you were personally there?
Yes.
Okay. And so there were two on-site inspections referenced in the report, one being in December and one in February. You recall?
Yes.
Okay. And does that help refresh your recollection as to which one you were on site for?
I think I was there independently, aside from those dates.
Okay, so you went on a third date?
I went there before that, yes.
Can you help give us a range?
It was before December.
Okay, before December. And did you have the authority of the property owner to be on site?
It's a place of public accommodation.
So, yes or no?
No.
Okay. And so flipping over to page 14 of your report, which starts to get into criteria on B under the local redevelopment and housing law. And I'll just real quick read into the record. So criteria B is the discontinuance of the use of a building or buildings previously used for commercial, retail, shopping malls, or plazas, office parks, manufacturing, or industrial purposes, the abandonment of such building or buildings, significant vacancies of such building or buildings for at least 2 consecutive years, or the same being allowed to fall into so great a state of disrepair as to be untenable. Sound about right? That's criteria B under the redevelopment law?
I was reading along with you, yes.
Okay. And so on page 14 of your report, you summarize your findings under criteria B as the study area, which is the subject property, qualifies as a condemnation redevelopment area under criterion B, as the building was previously used for a commercial multi-tenant plaza that has experienced significant vacancies, a building which, with many spaces vacant for at least 2 consecutive years, and a property being allowed to fall into so great a state of disrepair as to be untenable. Is that a good summation as to your findings under criteria B?
That's what the paragraph directly says, yes.
Okay. And so, touching on the first part, when you say previously used as a commercial multi-tenant plaza, do you have any evidence as to why you said it was previously used as opposed to currently used?
The lack of occupancy and the lack of tenants is what I was referring to by previous use.
Okay.
It wasn't under current use by anybody.
So you're not aware of any discontinuance of the use?
Define discontinuance of use.
So it's no longer being used as a shopping center?
There's a couple retail tenants that exist in there, but otherwise it's vacant.
So, right, but there's still an operation ongoing on site, is that correct? I'm just trying to understand the present versus past tense. It's not being previously used, is that correct? I just want to understand the part.
Yes, it has not been used in a number of years, so you may say that it is being used that way. I might say it's previously been used that way if it's not currently being used that way.
Okay.
So I think that's just a semantic debate that we can have about that.
Okay, well, so it's still in operation is what I'm getting out of that. So from there, you talk about what you classify as significant vacancies, and we don't have to get into any dispute as to whether there's vacancies or not. But what I wanted to raise with you is you mentioned in the report your justification for the significant vacancies is the rent roll from 1991.
That was a baseline, and the only reason we used that was to get to the what's the word? The demising plan, to look at the different units and their floor areas to determine, you know, which were units, how many were vacant, how many square feet per vacancy. So that was the basis to figure out what the floor area program was and how the demising plan was set up at some point in time.
Okay, I just want to go back to what you just said though. So you at least utilized this 1991 rent roll to help understand and calculate the vacancies.
It was to calculate. It was a good record of floor area as demised at some point in time, and we had no reason to believe that the areas have been re-demised.
So the floor area in 1991?
Correct.
Okay. So you use it for just simply the floor area versus trying to understand the tenancies and the vacancies?
Yes, I would hope that some businesses were fortunate enough to exist for that long, but that is not what I was after in that analysis.
Let's hope so, because there's quite a few years in our rent rolls between 2025 and 91, right?
I would agree.
All right, and then you also utilize the business records that are on file with the township currently?
I used as much evidence as I could.
Yes or no?
Yes.
Okay.
I'm sorry, are we trying to prove that this is not 85% vacant? Are we trying to say it's 84, 83?
No, what I'm trying to do is get an understanding as to what materials
I don't want to go through this whole thing about square footage, and this is going too long.
No, Mr. Adis, he has a right to put this on the record for his purposes, although if we could focus, I'd appreciate it.
No problem.
We
Understood.
We resolved 85% vacancy. If you want to dispute that, then dispute it.
Okay, we'll make it quick. So, apart from the 91 rent roll and the business records, were there any other materials you utilized in calculating the vacancy rate?
A visual inspection on site at the time.
So, quickly, just to wrap this up, you used the 1991 rent rolls, the registration statements on file with the municipality, and your on-site visit on, let's see here, it's the latter of the two, to determine the vacancies of the property?
To determine the vacancies, to determine the percentage of floor area that was vacant. I'm not sure exactly the question that you're asking. I don't want to answer a question where I'm somehow using 1991 evidence to talk about a current condition, or I'm somehow using business records to talk about a current condition. I looked at the totality of the evidence. I looked at, we did a field inspection, and we took all those things together to try to come to a conclusion regarding vacancy and to quantify the nature of that vacancy and the
Sure.
extent of that vacancy.
But you get what I'm getting at then, which is the totality of that evidence is three things, right? It's the 1991 rent roll, those registration statements on file with the municipality, and your visual assessment on site.
Right.
Okay.
So if you're at, yeah,
Just yes or no, it's those three things.
I do not believe there was anything else that we used to calculate or determine vacancy.
Okay. And so, let me just quickly go back to what we talked about in the beginning when you mentioned that you were on site. There was two visual inspections, one from December and one from February, right?
Yes.
All right. And so, the latter of the two, if I were to flip over to page 17, 18, 19, 20, 21, 22, 23, 24, and 25. Do it in groupings for expediency purposes. These are all images that you captured either during the December or February site inspections, correct?
Some images came from Google Street View. Were not captured by us individually. We cited and referenced those when that was appropriate.
Which ones?
There was one on unnumbered page 18.
The entrance vacancy pattern?
Entrance vacancy pattern. Underneath that, it says Google Street View.
Okay.
There was one that we took, so there's one on page 19 that comes from Google Street View. In the middle, it says, the top line says Suite 1B Autos Bar. There was one on page 22 that came from an online review website called Yelp. Otherwise, those came from site visits that were taken in December and February.
All right, and so that I get a better understanding for these site visits. The one in December, you used a drone to capture aerial images of the property?
A drone was used in December, yes.
Okay, and
Now, what's the point of all this? I mean, I'm not, to Mr. Adis's point, I mean, anyone who is ever driven by this plaza knows that it's empty. So like, are we disputing that it's not empty?
we'll get there. But yeah.
We'll get there. I mean, we're spending a lot of time on how did you determine that it's empty?
Is there information in the report, the veracity of which you want to contest?
I want to have an understanding as to the extent of each of these investigations, and what I'm also trying to understand is when they were talking about significant vacancies, what materials and what evidence were being used to reach those determinations?
I think that was outlined very clearly in the report.
That
I mean, it's cited, there's footnotes.
all right, so to wrap this up, what else I want to get to is when you were on site, did you go inside any of the buildings?
I do not believe we did.
Okay. And so the other item I want to just briefly address for criteria B is that when you were looking at the vacancies, did you contemplate that there might be tenants who would be paying but not currently occupying premises?
So it's an interesting point, and there's different definitions of vacancy. There's not a definition of vacancy in the local redevelopment and housing law. The vacancy that CoStar uses, which is one of the, I would say, most definitive sources of commercial real estate data, their definition of vacancy is a non-occupancy regardless of whether there's a lease or not. So there could be different definitions of vacancy. You know, different people of training and knowledge can disagree about what a word means. I'm taking the word vacancy under the circumstances to mean non-occupied, even if it's leased or not leased.
Okay, and so you didn't take that into account whether the property owner might be getting paid for other leases?
We tried to contact the property owner. We tried to ask for inspections. We tried to open a dialogue. There was not response from the owner.
Who did you reach out to?
A letter was sent by our attorney to,
And can you just let everybody know what we're looking at? Because
yeah, I'm referencing an email that's not part of the record. The original letter went from, is there a Mr. Tadaro? Is that the name?
yeah, that's me.
Okay. Sorry, Anthony.
Oh, it's all good. I know we used to be this formal with you.
Yeah, so, yeah, a letter was sent, requesting an site inspection. That's that letter, right?
All right, and would you be able to provide us with a copy of it?
Yeah, we'll get it to Mr. Lexstein.
All right, and what's the date of it?
Was it in February? February 18th.
February 18th.
It was transmitted February 18th.
Okay, so that was February 18th that you requested the ability to come out on site. But if I'm going in the report, just so I have my timeline right, there was an initial inspection where you used the drone in December of 2024, and then February 13th was a subsequent inspection.
Mm-hmm.
Okay. So those inspections were completed before you sent that letter?
We wanted to do an interior inspection.
Okay,
That's what the letter was requesting.
okay. It never did though, right?
As far as I know, there was no response.
All right, so all the pictures that you had, that you personally took are from the outside?
Correct.
And just for
And so-
clarification, that letter was actually written to Mr. Todaro, is what you just said, correct? Okay.
And so let's flip over now to your other finding of criteria D. Where if I'm looking at this, right? And you just help summarize for me, so I have a better understanding here. That there is a quote dilapidation for a lack of maintenance, roof damage, and unmaintained accessory improvements, parking lots, sidewalks, those types of things. Is that correct?
Those were things that I testified to, yes.
Okay. And so for the lack of maintenance, you referenced Appendix H, right, for several violations regarding property maintenance?
Okay.
Okay, and so those reports also identify that all of the items that raised were addressed to the satisfaction of the township back in 2023, right?
I have to review those.
All right, we can flip to it because it's, purpose of the record, it starts on 71 and it goes to the last page, which is 73. So these are complaint forms, correct?
Mm-hmm. Yes.
All right, and so why don't we start on 71? So these are all of the items stemming from a complaint report that you're using to justify lack of maintenance,
Okay.
right? I'm trying to just understand that. It wasn't clear to me in the report. Right.
Whether
Because you
That's why these
referenced,
things are being
you referenced-
provided?
Well, I mean, they're attached to your report as support for lack of maintenance,
Okay.
all right? However, if you go to the 71, right, where it says violations found and corrected, status passed.
On page 71.
Yes. Do you see that?
Yes, there's something else that says failed. So there was a failed and then a passed, I guess. So ultimately, yes.
Okay, ultimately, yes. And flipping over to 73, let's just do the same exercise real quick. You meant to see there where it says, inspection date of May 12th, 2023. Can you just read that off for me?
So there was an initial date of 4/24, sent notice, status failed, and then another 5/12, violations found and corrected passed.
Yeah. All right, so all of those items in your reading were abated back in 2023 or 24?
At that time, yes.
Okay. That time. And then you also mentioned as part of your testimony that there's a lack of, how do you define the faulty arrangement and design for criteria D?
You have to be more specific in your question.
Okay, so and how the property is developed and laid out. You mentioned that there's faulty design.
I see what you're saying, yeah. I think some of the things I was referring to were around, an example that I laid out was the worn striping and the fact that the traffic striping had basically been worn away, which is a maintenance item because it would just require paint. But if we all kind of accept that lane markings and paint-based traffic controls are important, not having them, whether they were there because of faulty design or arrangement or they were there because of lack of maintenance, kind of both get us to the same place, which is a faulty arrangement of a site.
Okay. And so, are you a licensed engineer?
I'm not.
Okay. Have you designed a site plan before?
I'm not.
Okay.
But I did review the site plan for this property that was approved by the planning board some time ago.
All right. And that brings up a good point. If you reviewed the site plan, I know there was some discussion on it in May 19th. Do you know the impervious coverage for the property?
Yes.
Do you know without referring to any of your notes?
Why would he need to refer to it without his notes?
I'm just curious.
It's in the report. Come on.
Is it?
I believe it is. Actually, I do believe it is.
We have
We're going to go back and calculate it.
Coverage.
It's in there.
I know it is. Well,
It said 78% on page 40
there you go. It's in the report. So why are you asking?
because it was going to be revised. They were going to review it. So I'm asking whether they have their own idea as to what that impervious coverage is. Because they're talking about the lot coverage without making their arguments, they reference the lot coverage as one of the bases justifying a designation for criteria D. So if we have lot coverage in the report as one item, they're going to take a look at it, revise the numbers. We don't have any revised numbers. So I'm just trying to understand.
Did you go back out and reassess what the impervious coverage is or recalculate it?
No.
I mean, you're going to have to do that, obviously. We can't have an incorrect impervious coverage number in the report.
Yeah, can I refer to Golda on this, because she had done some work since the last hearing on that.
Okay. Yeah, but do you know what the number is?
So this was in here for purposes of being a bit more illustrative. It was more about the subdivision with the auto zone, which is that property to the, I guess, left if you're looking at it, where when the site plan subdivision occurred in the early 80s, it was viewed as a 14-acre, whatever that percent was, with that being undisturbed. I think it was just a billboard at that time. And at some point, there was a site plan that took that auto zone and developed it up, and we compared the fact that these two lots are now covered. It might not be exactly 78%. It does say the words illustrative analysis on page 40 to point out this is illustrative using tools. No, we're not engineers. I don't even know if we can get that exact estimate as a non-engineer.
I mean,
Well, actually,
with the word approximate, go ahead.
I was going to say, my point that I raised at the last meeting was that there are tools out there that measure impervious cover. When I was reading through this report and looking at facts, the impervious cover was higher as per NJ Map 2, which has one of the better impervious cover mapping ones. So that 78%, I think it was closer to 81, 82%. But again, approximation here is significantly higher than what the current zoning allows for impervious cover. Was the point?
I think if we just edit the report to say, to include the word approximately,
It does say.
it says
does.
approximately?
Well, it says illustrative
It says
analysis.
estimates approximately 78% lot coverage.
Oh, it does say approximately.
All right, I mean, the word approximately is in there, I'm fine with that.
Then, I mean, because at that point, then you're relying to say anything more than 27% that's allowed by the zoning ordinance would constitute excessive lot coverage.
I don't think that's a fair statement.
But then then we need the number, and then you could base your opinions based off of what the actual coverage is.
I can tell you as an order of magnitude, approximately, it's in that 78 range. The things that maybe weren't calculated were some landscaped areas within the front courtyard. But as an order of magnitude, it's much closer to 78 than it is to 27. That's my testimony.
Okay. And you're going to rely on that for excessive lot coverage under criteria D?
Yes.
Okay. And so, one of the really the final criteria is criteria H. Standing on its own, do you opine that criteria H constitutes a sufficient basis for designating the property as an area in need of redevelopment?
So I would typically,
It's just, yes, or no.
Not do that.
Would you rely on criteria H on its own for this property?
no,
Okay. Did you recommend to the board that they would?
I don't think I did.
Okay. And then, so, the final item I wanted to raise here is the issue for curbing site access with the drive lanes.
Mhm.
Are you aware that's NJ, or really that, Route 35 is a state road?
Yes.
Okay. Do you have the standards for the curbing? I'm sorry, what are we looking at?
I'm looking at the report. I just was zooming in
Oh, okay.
to a piece of it. So I think one thing, if it's okay with the board, that I wanted to kind of supplement the record to council's point. There were two, and I'd like to read that provision into the record. All curb cuts shall be at least 15 feet, but not more than 30 feet in width, except on county or state roads where applicable county or state requirements are established. Unless specifically permitted elsewhere in this chapter, only one curb cut shall be permitted on any street frontage, and it shall be located within the center 1/3 of the frontage of the site. When I was testifying initially,
Can you just state what were we reading?
I was reading from ordinance section 21-33.2, which the excerpt of which is on page 37 in the report. And I think the point that I was more trying to make, and I got caught up on the first sentence when testifying back in May, was the second sentence. Unless specifically permitted elsewhere in this chapter, only one curb cut shall be permitted on any street frontage, and it shall be located within the center 1/3 of the site. On this site, as you know, the curb cuts are on the far ends, not in the center.
Okay. And so would you be able to build in connection with that zoning ordinance when it's a state road?
Clarify your question?
So would you be able to satisfy that ordinance standard, given that it's a state road?
I don't know.
Okay. And so you also mentioned an accident on Route 35 during May 19th. Do you recall?
I do.
Okay. And you raised, quite frankly, you mentioned that in your opinion, that the overgrown landscaping and shrubs probably caused that accident?
I'd like the opportunity to review the actual report.
Sure. I'm talking about your testimony anyway.
Yeah, and I don't have a transcript, and I don't think you do either. So I'm trying to just be as precise as I can. I do recall there was an accident. I do recall that it was, I believe, at one of the driveways. Obviously, when there was a vehicle egressing.
Which driveway do you know?
I think I'm pulling up a record. Okay, as we sit here right now, I don't have the specific driveway.
Okay, and
Do you, if it's in the report, can you tell?
it's not, and I wanted to get to,
Not, okay.
right, so did you review any of the police records?
Yes.
Okay, were they attached to the report? I mean, there's,
No,
I just want to clarify for the records, there's a list of appendices, and it's not one of them.
just
okay.
code violations.
All right. So it's your opinion that it caused accident, but you haven't included any evidence to justify that opinion. Is that correct? You didn't
As
include
we
any
sit
of
here
the...
right now,
correct?
I think that that's correct, yes.
All right. And so there's several pictures, because like you said, there were 2 inspections, and honestly, right up in the first photograph on the cover page, you show several pictures of flooding, or really some puddling and poolage. Do you have any idea when you took those photographs when the nearest rain event was?
No, but I'm sure that there is a way to find that out.
Okay, so when we're looking at these photos, because what you did was to show that there was instances of puddling and pooling,
Mhm.
justify that there'd be a need for stormwater improvements, right?
Yeah, in part, yes.
Okay. But there's nothing to tell the board or tell anybody that it might have just rained 2 minutes or 2 years before you took that photograph.
I could say it was probably closer to 2 minutes than 2 years.
All right, but you understand my point.
I do, but at the same time, after it rains, if it's not raining in the moment, the way that the water pools on a site is evidence to us of how the site is draining, or not. So that's what we were documenting.
Okay.
And the report does indicate that you saw moss, indicating long-term standing water? Yes?
Yes.
Okay, thank you.
So that's what I wanted to just reiterate here. So standing on its own for criteria D, would criteria D on its own constitute an area in need of redevelopment?
Yes.
All right, how about for criteria B, standing on its own?
Yes.
All right, thank you.
Okay.
No further questions?
Can I ask you questions? All right, I just want to, there was something that was not brought up when you were talking about the vacancy, and I think it's really important that we go back to this, that we received testimony from a member of the public who identified herself as a real estate agent, saying that they were not able to rent space despite having multiple clients who were interested in it.
Mm-hmm.
Can you address that at all as part of this ongoing vacancy?
I can do one better than that. I actually have a representative of the ownership here who could tell you why.
Okay, great. Can we hear that? That would be, Mark, can we do that? Yeah?
Yeah, I mean, well, yes, it's up to him.
Absolutely. But
Please, I'm very curious.
yeah, you guys don't leave the room, but
Yeah, don't go far.
yeah, I think
It's a bad thing.
The project's going to want to swear you in, obviously, so.
okay. Do you affirm that the testimony you're about to give will be the truth, the whole truth, nothing but the truth? And just state your name for the record.
Z, Berger, Z-V-I-B-E-R-G-E-R.
Could you, I'm sorry, you gotta back up. Just start again.
Z, zebra, V-I, Berger, B-E-R-G-E-R.
Okay, and what is your relationship?
I'm the managing owner of CJ Jersey Realty, LLC.
And that's the owner of the property?
Yes.
I see, a managing agent. All right, good, thank you.
Managing partner.
Managing partner?
Correct.
Okay.
All right. Thank you. So you've already introduced yourself as authorized agent, managing member of the property owner.
I'm authorized.
And how long have you really have ZJ Realty on the property?
Since 2000, about 24 years.
Okay, so 2001?
Yeah.
Okay. And so, you took ownership of it, you've operated a commercial shopping center, is that correct? All right, and so, more recently, have you decided to sell the property?
Yes.
All right, starting when?
We did that in 2021.
Okay. And so, starting when 21, when you were actively trying to sell the property, were there any requests or requirements from interested parties and contract purchasers?
Starting from 21,
Yeah.
we had some interested parties, yes.
Okay, and did they ask that you did not renew the leases?
That's correct.
And did they ask you not to sign up new leases?
That's correct.
And why is that?
Because they didn't want to purchase property and then have to worry about buying out all the tenants.
So
The
they could,
purpose was for redevelopment, and they were going to change the nature of the place, and they had to knock down that building. So therefore, they preferred not to have me renew any leases or negotiate new leases, unless I had their permission for a short term. That was like,
and so, is it fair to say that their requirement, and I want to get into the specifics, I'm trying to be very careful here, because you don't want to get into the negotiations, there's other deals, because obviously they didn't work out, but they, to the greatest extent possible, they wanted the site vacant.
Yep.
Okay. And fortunately, you were able to find a buyer, is that correct?
Yes, I have now a buyer.
And you're under contract?
Yes, I am.
All right. And
Very serious one.
all right, and trying to close in a matter of weeks?
Yeah, in 20 days.
Okay.
So, Mr. Tadeo, just because I want to go back to your previous point, you were very concerned about the use of the phrase previously used.
Mhm.
And I don't want to mischaracterize what I just heard, but to me, it sounds like they had determined that they were winding down their business operations in preparation for a sale. So they were not currently using, they were winding down. Is that correct?
Well, it's still being used, right? There's still some tenants there. It's just that if they don't have any, I mean, if they weren't going to re-up somebody with an expiring lease.
Right. And so the number, and that was in 2021, which is 4 years ago, which is longer than 2 years is per the statute, right? Okay.
Mm-hmm. Oh, no, absolutely. We're not.
Okay. I just want to make sure that I understand
Repeating that
perfectly
there's
here.
vacancies. We're just trying to explain why there's vacancies.
Sure, and that's
And
fine.
that it was going to be temporary for the
How
New
long
Year's.
was the property under contract in 2021?
Oh, jeez.
How long was it under contract?
During which period the potential buyer said, we're looking to redevelop and we don't.
Well, we had a few of them. We had that, and we had the last one was in 24, which we had a signed contract. We would have sold this property already. Except that particular buyer just kept on pushing and pushing and pushing. It was a 60-day, then he went another 45 days.
21 or
And 24, yeah. So when we finally realized that he wasn't purchasing it, then and so now we're up to a real, we know this guy's serious because it's a 30-day. The other guy was, but this guy is 30 days, and he's a well-known person around this area. He's done a lot of work. He's very proud of his work, and I know that he can do a great job. He wants to close and start right away. He's already, you know, doing a lot of due diligence,
And
spending a lot of money.
Can I ask a
And so-
question?
Yes.
Let me just ask a question. So the town has received, it's my understanding, multiple, over the years, applications to open businesses within the plaza.
I mean, tenancies.
Yes, since 2021.
Well, what
I
kind,
mean, are you saying that's not true?
what kind of tenants are you talking about?
I mean, we could swear in our secretary over here who's in charge of that, and she'll tell you. But there's been multiple applications over the years, which just sort of flies in the face from over the last couple of years.
Maybe not very few though, not many.
Yeah, but
There have been a lot, from my understanding. I mean, Nicole, I can swear you in, and you can tell us, because you're in charge of that also. So, Nicole, let me just,
Well, hold on. Nicole, do you want to be sworn in?
she's gonna have to, because she has information.
Okay, all right.
She doesn't have a choice, really. I mean, she has information.
Sorry, Nicole.
No.
Trying to give you some agency here.
Hold on, I just want to know, I don't understand the question. So you mean that those who file applications?
No, new businesses.
Do they actually start their businesses? Do they actually start?
Well, why don't we
premises?
start her in and get the
Okay.
information, because it flies in the face of what you just said, and we'd like to clarify this. So do you swear any testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
And just state your name for the record.
Nicole Ackley?
All right, and Nicole, in your capacity, I understand you're the planning board secretary, but do you serve other functions for the township?
Trying to think it. Yes, so I am the planning and zoning board secretary. I also was the business license coordinator for 3.5 years. Took in new business license applications, did engineering reviews, so.
All right, and can you tell us what your experience is with our applications to open businesses at that plaza?
Since 2021, we've received at least over a dozen new business license applications, not just applications, businesses that have opened, spent their year there, and then left. And we have a new business license application that just came in last week.
For our own place?
Yep.
You're talking about growing kids?
That's what just came in, but I could also talk about Just Play that came in.
Just Play.
They just left. Just Play.
Just Pay is leaving now, correct, at the end of this week.
But that was a new business that came in since 2021. So there were.
Yes, that's it, that's one, Just Play. Growing Kids was there from a long time before. They're extending their lease to another
Right,
place.
so that's the one that we just.
Yeah, but they didn't do it yet. They're not going in until July 1st. So you have one tenant, that's it.
Well, I don't think that's what she's
That's
saying.
not what I'm saying.
And either-
Not putting on. So what I'm telling you is that since 2021, we have received over a dozen business license applications that have gone into your place and then left since then.
But they never got to that place. We don't have them as tenants.
But either way, well, no one's disputing that there's
It's
vacancies.
on our rent roll, but we don't have them. Maybe they applied.
So-
I think that the
So-
issue is that the testimony given is that they've intentionally allowed tenancy to die in the premises because they wanted to hand over a vacant property. It's not that you're conceding it's vacant. You're trying to make an argument. The reason it's vacant is because they're intentionally not leasing out the premises. And what Nicole's testifying to is that doesn't comport with what she's experienced, because there's been licenses that have come in. It's not one business, it's multiple businesses, and I didn't anticipate this testimony. We can get that information
I'd like to.
for the board of different licenses that have come in for the property.
No, just Pay, that's it. No short term, nothing. I don't know what she's talking about.
And that's if the board even wants to see this, but nevertheless, it's.
Does the board have questions about the vacancy rates of Orchard Plaza currently? Is anyone unclear? Does anyone have feelings? We've now heard our testimony from topology, and we've heard the testimony or the questioning from Mr. Tadeo. Is anyone unclear on the
Just
vacancy?
for fidelity, I've driven by the place full 360. I used to go to Otto's and some other places there, so I'm very familiar with it, and it doesn't really matter to me. And I think he also said that they didn't want to fill it unless they had permission from the probable purchaser. So that didn't mean they weren't filling it. And I don't put words in your mouth.
Oh, that's what Mark said, is definitely true. That's what we did. We did not have any substantial people coming in there because we knew that we're gonna get hurt by finding buyers. And if that one and just one, Just Play, by the way, they came to 21, that's just when we made our decision. So it's like a month here, a month there. But as far as I know, I don't know anybody else that came into that place, honestly.
And
Okay?
so, yeah, and we can move on to the next part,
Yeah.
which was I wanted to raise in here that there were some complaint forms in the report.
Actually, before you go too far on that, that was my next question for you. In just reading this report, and I want to make sure that we're not going down a rabbit hole here. On page 27, in that section that starts dilapidation, right, lack of maintenance, it doesn't actually say that there's a number of outstanding complaints that have not been addressed. It merely highlights those complaints as a history of dilapidation on the site, and then proceeds to share a number of photos of various areas of the site currently that are, I think, to the naked eye, dilapidated. So Appendix H was a historical reference, not something for current outstanding violation. Is that your understanding as well?
My understanding is that it was used to help support the finding that there's been a general lack of maintenance.
Mm-hmm.
So items have been cited and then addressed, well, runs counter to the idea that there's been there's a real lack of maintenance here.
Well,
That there's-
I would...
Violation status.
We're not sure
I
if
would
there's any
disagree with
clear-
that assessment. They're being fined and they're being forced to address it, but are you disputing the photographic evidence on the subsequent pages?
Well, I wanted to just go to Appendix H. We'll get there.
Okay.
So for H, they mentioned violations. Were you ever fined?
No, we never got any fines. We never received any violations in the mail like we had been for the past 24 years when somebody came down to give us a violation, and we took care of it and sent it back. You know, we had to check the box that it was taken care of. We had something very unusual for the first time. A inspector, Stephen Sexton came to call me up, says he wants to meet me there. So I went down there, and he says, I want you to do this, 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 and this. We wrote up everything that he did. We emailed in response to that. We took care of this, we took care of that, we took this. We still ordered the material, we need another week for this and for that, and subsequently, and within 2 weeks' time, everything was done, okay? He came back again a few months later. I want you to paint the whole facade, everything, front, and a couple other minor repairs. We did that. And a couple of months later, he came again. And he said, I want you to paint the entire back of the wall, the whole building, and the two sides. And we did that. And then, lo and behold, after everything was done, all of a sudden, the media came out with all the, recommendations for, what the town's gonna do to me, and destroyed me, okay? Now, we didn't get anything after that. He didn't come over to me and say, hey, this is no good, this is no good. He didn't give me a notice, hey, we don't like that, it's vacant. Anything that had to do with improving what the town wanted me to do. I'm here for 25 years. I've been doing pretty good also, by the way, okay? Because I can show my rent rolling right before COVID. It was over $900,000 a year, okay, gross. Okay, we weren't doing bad. We got hit by COVID, and after that, we decided to sell in 21. That's all. But we didn't get any violations.
When I get back to the point, did we get any violations? Did you get any?
No.
So no formal violations?
No.
And any fines?
No.
And they were all timely addressed, every item that was raised in those complaint forms?
Yeah, I have emails.
Okay. And so, to the chair's point, that was more historic, what's going on based off of when the site pictures were taken in February. So let's start on page 27, trash and debris. Did you take a look at this?
All I know is after that report, I went down to the shopping center, and I didn't see any of it.
Okay, so
And I just like to conclude that almost everything that's in this report is already taken care of. Okay? Even though I have a buyer, I took care of everything that I could. I only held up on the sidewalks, that's it, and the back lot, that's it. Everything else is done.
Including
all
the
this stuff
stormwater
we're talking
basin?
about this and that. What?
Including the stormwater basin? Because after trees,
Yes,
stormwater is my favorite topic.
Most of it is out. Most of it is out. The contractor asked me to wait to the end of this week to pull out some rods or something from the other side next to Pet Boys.
From the storm?
That's in the storm. He said he's pulling that out. That's not a problem for him. Everything in those pictures is gone. You can go there. It's not there. The potholes are all clean. The arrows for the streets that we were talking about for 10 minutes, they're down. The next day, as soon as I saw that, I had my guy do that. In the same way, I would have expected the township inspector to come to me and say, hey, he's been doing this since middle of November, before November of 23. Why doesn't he come over to me and say, hey, you got problems here? Let me take care of it.
Can I ask a question? Why does it take the town to go out and point something out for you to do the care that needs to be done to fix it?
Well, most of the time, it didn't need to be. And over the years, I have very few violations.
Forget violations.
Well,
Because it's not about violations. Violations occur because there's something that's been neglected.
Neglected.
Okay, why does it take, and it's appreciated that you, as soon as you get a violation, you take care of it.
Yes.
Why does the violation have to come in the first place? And because it's not just one violation, it's not just one issue. You're indicating you saw the report and then you took care of all these things.
Yes, that's correct.
Right, but why did it take the report for you to go and take care of all these things?
Okay.
What's going on
When I
otherwise?
was in contract, that was my mistake. When I was in contract, I thought all the obligations and responsibilities would be of the purchaser. And nobody would care much because he would either demolish it or do whatever he wants with it. It was my mistake. I should have, just for that year, I did rely on, when I got that information, I took care of it.
So you're saying this all happened in 2024, that 2023, everything was fine?
No, in November of 23 is when he started. I think in March of 24 when everything was complete.
What was complete?
All the work that he asked me to do over the past
I know, but I'm talking about what happened prior to November 23, when you began to get these violations. Why was the property able to fall into that state of decline
Well,
prior to November of 2023 when you got the violation?
before he answers, I just want to clarify that there were no violations issued.
We didn't have that.
Well, you got the complaints from the code enforcement
Right,
officer.
and we
Prior to getting complaints, fine. We're semantics, but I get it. I forget the word violation. You were contacted by the code enforcement officer, and then the testimony is as soon as he got those complaints, he took care of it. Why did it take, what was going on prior to November of 2023 that the place was able to fall into such decline?
It wasn't.
No.
It wasn't in decline, only in 23. Like I mentioned to you, but 22 was fine.
I'm gonna,
We didn't have.
So what happened in
hold-
2023?
Sorry.
I'm gonna object it because these are complaint forms. They're raising issues as to what they deem to be the poor state of the condition of the property. There's nothing on record as to what standards they fell below. So state of this state of disrepair argument, I mean,
Well, your
We don't
client's
see-
acknowledging that there were issues that
Because-
needed to be tended to, and as soon as he was made aware of them, he took care of them. If everything was wonderful and fine, your client would have said, "There's nothing wrong here. What are you talking about? You town, you're crazy."
I don't.
But that's not what he did. He's acknowledging that when he was told there was an issue, which he's acknowledged about 4 times, that in November in 2023, these are when all these problems occurred. And as soon as he was notified of them, he took care of them. So I'm trying to figure out what happened in 2023 that you're saying in 2022 everything was wonderful and everything was perfect.
That's right.
Then in 2023 everything went downhill
I
and
didn't
began
say
to fall
that.
apart.
I didn't say it went into decline. You said that.
Well, you.
I'm just saying it was something that he picked on, and he wanted to take care of it. He said I should take care of it. I would ordinarily take care of stuff like that, but I don't have to. I don't have to paint the back of the building, all the whole way. I think that's a little excessive. And there was other things as well that was really quite excessive. A little thing here and a little thing there, and nobody. You go to the most modern strip malls. You don't. I mean, they're not going to. The one bulb. He said 1 to 2 bulbs. There's around 35 or 40 posts with brand new LEDs, and then they pick out one and say, "Oh, look, it's not working." In that report, it's ridiculous. I mean, we're not perfect. It's not decline. This is just plain old nitpicking, and that's what he did, and that's fine. I'm okay. I was okay with it. I did it. I spent a lot of money, and I was fine, and that's all.
Well, what about the arrows what about the markings
arrows
on
I
the
did
ground?
also. I never realized there was a problem with arrows. I'm here for 24 years. No inspector ever said that to me. None.
Forget the inspector.
No, how do I know that that's a problem?
But you've
So
been
I
managing
have signs. I have signs on both sides. It says you can't, do not enter. Big sign.
So is this the only property that you manage?
Yes, in Jersey.
But you manage other properties.
No, actually, a little triple net. My other properties in New York are triple net. Why is that? an issue?
Well, my point is that you have some experience in this field. You've been doing it since 2021, since 2001. So does it take someone coming to you to tell you that there's a problem before you are cognizant of the fact that maybe I need to address the issues and that everything you just allow it to just be until an issue is brought to your attention? For someone who's been managing property since 2001 at the very least?
This was nitpicking. This was not,
Okay,
there was nothing wrong here.
well, that's your opinion.
Well, that was my opinion for 24 years, and nobody in this township said anything about it. The same, all these items were here before.
And my only point is that I don't know why you have to wait for someone to come to you to tell you there's an issue before you go and address the issue. And your argument is that he didn't think that there were any issues really to be
I
addressed.
wasn't aware it was an issue, that's correct.
Okay, fair enough.
Okay. Does anyone have any other questions? You don't have any concerns about criteria H?
Criteria H is just on its standalone basis now. Well, actually, we have a planner who could talk about it a little bit more from a planning perspective.
Does anyone want to talk about criteria H more?
No.
I have a feeling their planner is going to, as he just said.
Do you want to talk about criteria H more?
Oh, wait, I'll let it come out. Unless there's something, I mean, it's a planning criteria, so.
H is not required as far as us evaluating whether the site.
Yes, it is. It's one of the criteria that we are evaluating it on.
I know, but it's not. It's a standalone. It's not required for. It's B and I think B and D are, and H is additional information.
In the most technical reading of it, no. Our planner is advising us not to base our criteria solely on H, but the statute itself does not say that. Just so we're clear, unless I'm mistaken, Mr. Lexstein.
No, but I think you can follow the advice of what the planner is saying, and that is what he's saying, so.
Right. Okay. So if you want to bring up your planner, if there's anything else you want to add, I think we're there. That's.
Yep.
Sure. Yeah, do you swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
And just state your name for the record.
It's Cray, C-R-E-I-G-H, Rancamp, R-A-H-E-N-K-A-M-P.
And what, are you with a firm?
Myself.
You're with yourself?
Solo.
And you're a licensed planner, state of New Jersey, and your license is in good standing?
Yes.
Thank you, go ahead.
So it's
You
fine
don't, yeah,
for-
you don't need the voir dire, I mean, we accept them as an expert.
Okay, great. And Mr. Rankoff, you reviewed the area need report in connection with this preliminary investigation, is that correct?
I did.
All right, and before we get into the report, can you kind of just give the board benefit of just a rundown on the process of where we are? I feel like maybe it got lost a little bit, just that this is the area need study and what the criteria is that we're looking at.
Well, yes, I mean, there was a great deal of discussion about property maintenance issues and sort of municipal administration issues. None of that is directly relevant to a declaration of blight leading to the possibility of government engaging in condemnation. That we'll actually be talking about the designation criteria under the legislature and under case law since. And I agree with your planner's testimony and the gentleman's conversation that H alone by case law is insufficient. So we'll be focusing on B and D this evening.
All right, great. And can you get into criteria B and what really, what?
Will do.
Okay.
So as the gentleman said, there's not a whole lot of debate on whether or not the center has had some amount of vacancy. I'll leave substantial for whatever litigation happens in the future. It's certainly a center that's had vacancy over the recent time. But what's important is we have a federal constitutional control over the use of condemnation. And that's a finding that the instrumentality of private capital will fail to operate appropriately, which justifies governmental intervention. Our legislature tries to convert that into criteria, and the criteria B was recently amended to add this 2 years of substantial vacancy in retail as one of the criteria a board could reach the ultimate conclusion that designation and the possibility of condemnation was necessary.
Sorry, I'm sorry. Are we? I think we're voting on redevelopment, not condemnation, correct?
No, we are voting on condemnation redevelopment. It is not our decision whether or not it gets condemned. It is the council's decision. They are not forced to condemn it if we were to approve this. They could move forward with the redevelopment plan lacking condemnation, correct?
They could.
They could.
But
They-
let me finish my sentence. Your report recommending that it be available for that is itself an appealable action. So it's not as if nothing happens until the governing body acts. What you've done is an act, and that act can be appealed whether or not it meets those criteria.
So essentially, the council sent this to you as a area in need of redevelopment study with condemnation, and the statute requires that they must be very specific with whether condemnation is part of this or not. They can either say it's not with condemnation, or they can say it is with condemnation.
Our vote is whether it's with or without?
And so your vote is with condemnation. That's what you're being asked to determine, is whether or not this is an area in need of redevelopment with condemnation. You're not doing the condemnation, as the chairman said. That's ultimately up to the council, but it is incumbent upon this board to find whether or not this property meets the definition of an area in need of redevelopment with condemnation. That's a very, very important finding that this board has to make. Correct?
We clear? We all clear?
Do my professionals agree with me on that point? Yes.
We all do,
Okay.
yes.
We all agree.
We all agree.
Okay, all right.
And the criteria that you're offered by the legislature is this vacancy issue in retail. That's a relatively new amendment to the statute that hasn't been tested in court yet, and this may be the case that does that. My point to you is that the evidence that you've heard thus far is you have a landowner who is actively seeking private redevelopment, revitalization of the site, has been engaged in finding buyers actively for the last couple of years, and is currently under contract to someone who wants to do exactly that. So the evidence before you is, yes, the center has been vacant. I won't use the word substantial. A lot of vacancy. We'll leave substantial to a judge someday. A lot of vacancy on the site. But that alone is not sufficient evidence to show that private capital is going to be insufficient in being able for revitalization to occur here. Does government really need to intervene and threaten condemnation to make something happen? And the evidence that's before you is no, because that's already in process. That's what's happening anyway. So I would suggest to you that criteria B is not met by the facts in this case that's before you. Now, criteria D is a very important one. It's in summary, I would call it the dilapidation criteria. And case law tells us, and your planner at page 13 summarizes one of the recent cases, to say how important substantial evidence is in the interior of the building. Evidence from interior of the building is important. That's part of the summary. And unfortunately, that's not what you've been offered. You've been offered a whole series of what I would refer to as maintenance issues, and maintenance issues are explicitly under case law not sufficient criteria for a designation of blight. You haven't been shown structural deficiencies in the building. You haven't been shown that there are interior problems in the building. You have been shown, for example, notwithstanding the case law that says maintenance isn't an issue, the first heading on page 27 is lack of maintenance. It's already not a criteria. Roof damage was remotely assessed. There's standing water. No comment about when rain happened. Is that bad? Is there a leak? Is there structural damage? There's nothing further than an indicator that there might be a problem. And in fact, the report concludes that there's increased risk because of water, not in fact that there isn't structural damage impacting the building. On page 29, we have instances of cracked concrete, and that is unattractive. Unattractive is not a sufficient blight criteria. Page 31, we're told about missing and faded signs. That's a municipal enforcement issue. That's maintenance. Page 32, graffiti and older electrical boxes. That's not structural problems. That's not a blight criteria.
I believe it says broken utility box. Broken utility box.
And does your planner have evidence that electricity is not flowing through those systems?
Do not
No.
know.
Page 35, we have inoperable lights, not counting how many of them or where they are in the field. And again, that's a maintenance issue.
So you said there's nothing about the internal. On page 19, I see pictures of the inside of the space.
Your planner has already testified he was not in the building. So at best, he's taking pictures from outside windows into tenant spaces. And measuring tenant improvements is not telling us whether a wall's falling down or whether the roof is in trouble. It's not documenting the kind of structural infirmities that would justify a blight designation. So we can agree, we can disagree. You can decide that superficial stuff is enough for you, but that's not what the case law tells us. And on faulty layout, we're told of a municipal ordinance on a state highway. There's no statement here that we're inconsistent with the state highway access code or that one way in and one way out is inappropriate overall in terms of site planning, just that it's inconsistent with your ordinance. And on coverage, yes, it's higher coverage than your ordinance. But if we're going to conclude that it's a blight designation criteria for every retail site that has 80% coverage, you're going to have a lot of blighted sites around the state. I would suggest to you that that's not a sufficient designation criteria for blight. So it's not that I'm saying that these things are not there, but I'm specifically saying these are maintenance issues. These are the kinds of things that are typically dealt with between a property owner and a municipality through property maintenance requirements. And the evidence that you have, and you just went through it, so I won't do it in detail, is every time the municipality generated a complaint, that complaint was closed with complete satisfaction. The work was done. When people stopped providing those reports, that work stopped, and council's right, maybe that shouldn't happen, but that's an enforcement issue. That's not a blight designation justification for condemnation and the intervention of government in the redevelopment process on a site that's clearly already on a trajectory to be developed privately. So I'm not negating anything that the folks from Topology said to you. What I'm saying to you is that this is overreach in terms of being a designation report justifying condemnation.
Can I ask a question? How do you know the site is on the process of headed towards redevelopment?
The inside baseball answer is I know who the buyers are and I know their counsel. That's the honest truth. The reality is you've got a landowner who has serially been under contract. Why people haven't closed, I don't want to speculate on what they found during due diligence or their meeting with the towns or whatever happened in the past. But there's active evidence that the act of selling the property has been in process now for a number of years.
Right, but the fact that someone's buying the property doesn't necessarily lead to the immediate conclusion that the person who buys it is going to automatically develop it. He could sit on it.
There are not a whole lot of people that are spending $10 million to sit on it.
These people sat on it, and the current owners sat on it, and since 2021, and haven't done anything with it other than try to sell it.
We can agree to disagree and see what a guy in a robe says.
Anything can happen.
Right.
They could buy it. They could wait for values to go back up and decide at this point. It's all hypothetical. We don't know. We haven't seen plans. Nobody knows what they're actually going to be doing or not doing with it.
And also,
the question is which side is proving what? You're proving that private capital is incapable of doing it, while the evidence before you is that private capital is trying to.
Well, we don't know, but there's no evidence of the private. All that's been established here is that someone is actively in the process of buying the property. That does not logically go to the next step, that the person who buys it is going to clean it up or develop it.
But the shoe's on the other foot. It's government trying to demonstrate that private capital will not be sufficient in revitalizing.
My point is you're stating for the record that there's evidence in place that redevelopment is going to happen. And my only point is, I'm not negating what you're saying.
Right.
All I'm saying is that your statement that the property is on the track for redevelopment doesn't have any foundation to it because you know nothing other than the fact that there's a contract.
I won't disagree.
That's my only
You've
point.
characterized the facts correctly.
Okay.
We interpret them differently, but the facts are the facts. Right. Somebody was saying something.
He got to my question. Okay. It's the same thing. Just because there's a buyer, I've known plenty of folks who have big dreams of restoring antiques they find at Goodwill, and it never happens, which this is that at a much larger scale. This could potentially turn into an amazing site, but there is no proof that it will. It's just there's a contract, and that contract isn't finalized. The closing hasn't happened.
Well,
so
I'll leave to council. There is a contract
right now.
Whether there's a closing is a different issue.
Is the closing before midnight tonight? No. So this board is going to vote on something that has not closed, one way or the other. If we take a vote tonight, there will not have been a closing.
Which is why we asked for it to be put off for a month.
That's outside of our purview. And I understand where you're coming from. But I really want to just go back to this point, and I want to make sure that we're all very clear on this. If we vote on this and agree with our planner's testimony, it still does not obligate the council to condemn it. Am I correct?
You are correct.
Correct.
And Mr. Chairman, I'd also submit to you that even if the closing was happening today, right now in front of us, that wouldn't be a reason for you not to vote tonight because the property is what the property is as it is today.
May I take that as a question?
I wasn't making a question. question. They're welcome to testify.
Thank you, sir.
We'll let Mr. Beal ask his question first, but
All right, I'll come back to it.
It's more of me thinking out loud, so Mark, just follow me here. If I heard them correctly earlier, they have a closing in 20 days, and our next board meeting is more than 20 days away. By that time, we would know who the buyer is. And if the buyer is one of the three people I think it could be, then that would lead me to think it could be redeveloped. I'm thinking out loud here. I'm not merely making a point. What's the harm in us pushing this to the next meeting? That's just a question.
It's up to the board. But my only point was that you are obligated by the town to make a determination, and you shouldn't be making that determination based upon whether or not they have a contract. The board can do what it wants to do. I'm not telling you not to. What I'm saying is there are no legitimate grounds just based upon the fact that there's a contract. It doesn't change the circumstances of the situation of what you're being asked to conclude by the council.
Okay, so let me just add some more fidelity. So the reason I phrased it that way was the last meeting you had someone show up to defend the owner, and he seemed to just find out this was happening and showed up maybe not totally
Well,
prepared.
that was Mr. Tadara.
That was actually.
Oh, was you, right? Okay.
Mr. Tadara was also very clear that his client was noticed appropriately.
Yeah, he did.
It's just he had
I
only
agree.
found out that evening.
I agree. So I don't know.
Or that
I'm
day,
not saying
sorry.
either way. I guess I'm weighing in with my partners over here. If giving them 30 days is going to be a bad thing.
Can someone clarify, simply, I think I know, but the difference between redevelopment with and without condemnation? What would happen if the council determined condemnation versus non-condemnation?
Well, if they decide to proceed with condemnation, that's the adverse taking of the property.
It's eminent domain.
It's eminent domain.
Purchase and all that.
Exactly.
but they could go forward with a redevelopment plan that does not include that.
They absolutely could.
Right. So had they chosen, and they did not, had they chosen to go through non-condemnation redevelopment, it would put them at the same place. If we move this forward, then they can come up with a redevelopment plan and choose whether or not to condemn it at that time. And the redevelopment plan could include any number of other, let's call them creative ways to help facilitate redevelopment of the site. We all in agreement on that?
No?
No?
I'm waiting for my turn.
All right, well, come on, let's hear it.
So yes, I agree with the part that the governing body ultimately has responsibility. But you have responsibility for the document that you're being asked to adopt. That adoption creates a document that then needs to be appealed if you're the landowner. So we're all going to start spending money immediately upon your adoption within the 45-day appeal period, and we're going to be arguing that your criteria D was light, that H doesn't count, and you went overboard on criteria B.
H
All of
doesn't
that-
count?
It's a state planning criteria. It's a throw-in. Our courts have decided that you cannot designate blight for condemnation based on H. So H is from a litigation point of view, it doesn't count.
But I mean, it furthers our master plan, something that we wrote
It
specifically.
sure does,
in.
and it's great for the state plan if sites develop. And any planner could give you great pros on how anything advances H. And the courts have figured that out. So they basically said, okay, we get that. We really want to talk about the criteria for condemnation that are about how bad the property is. So I'm not trying to convince you not to think about H. I'm just saying when we get to the next step, a judge isn't going to want to hear anything about H. It's just over. H is done.
My only point is, if they were sold and you had the developer in here, right? I'm sorry, not developer, because now I got the redevelopment in my head. But say the new buyer is sitting here in this room, showing you that we have these wonderful plans for what we want to do with the premises. What does that mean for the board? Does the board say, okay, we'll give you 60 days to develop it before we finish the hearing? I mean, it doesn't work that way.
Can I finish what I was going to say?
I thought you were done.
No, that was one of my
jumped in.
three. I've got two more.
Go ahead.
The question, though, was proof of what, by whom, to whom. You keep saying our contract isn't enough for you to put this off. And I'm not suggesting that contract is proof. It's your job to find, as an affirmative finding, as your counsel represented to you earlier, in recommending to the governing body that this is a designation with condemnation powers, that you have found that private capital will not develop this site appropriately. What evidence do you have to come to that finding? All I'm saying is that there's at least alternative stuff out there which undermines the idea that you could reach that conclusion. I don't think you have any evidence that demonstrates to you that the private sector is incapable of developing the site without government condemnation. You don't have any evidence. So, not to beat that to death, the last thing about why it matters. There's a thing called condemnation blight that planners and lawyers understand. That once this process started, once the newspaper articles started, it impacted the way people look at the site. Because an investor is looking at the site and saying, oh, well, I'm going to spend money going through due diligence, but the government could take it away anyway. Why am I going to bother? As soon as you start this process, it has a darkening cloud on the private redevelopment process. So it matters. This is not just something that we can do this and it doesn't matter. The governing body will take responsibility. The thing that you're being asked to do matters. I'm done. Go ahead, Council.
I absolutely agree that it does matter, but it's not our determination. The governing body has asked us, does it meet the criteria? Not any of those next steps.
But it's well within your scope to say it meets the redevelopment to be in a redevelopment area, but we're not recommending it be designated with condemnation powers. You can do that. That's part of your power.
You do have that ability. You could recommend it without eminent domain if you wished, but that's not what you've been asked to do by the council. So, and the planner can, our planner should come back up when this is all said and done and refine.
Yeah.
Well, is he done?
Are you done, Craig?
I was done responding.
Okay.
Okay.
And by the way, we know each other and respect each other.
That's fine.
This
Well,
is
we
not
all
going to turn into a
respect each
cat
other,
fight. We
so-
can actually sit
We'll
next to
share
each
a
other.
microphone. It's okay. So let me just ask one question about the instrumentality of private capital, and I just want to make sure that we're not like imposing or inventing a new standard. There's criteria A through criteria H. Only one of those criteria speak to the instrumentality of private capital. You're saying that there's a federal constitution, maybe some federal case law out there.
Yes.
The charge, the New Jersey statutory state law charge, is for this board to evaluate by the criteria that's contained in the local redevelopment and housing law. Isn't that correct?
No.
So they're supposed to look for other criteria?
They're always required to be lawful.
So in this case, the statutory process that exists for this type of process is to use the statutory framework that exists in New Jersey.
Look, if you're cleverly asking me if we stay within the four corners of the statute, do we avoid the question? And the answer is maybe. This amendment to the statute that put 2 years of substantial vacancy is relatively new and has not been tested in court.
I agree with that.
This may be the case that does that. That's all I'm saying.
It may be that, and maybe one of the other ones that I'm working on.
Okay.
So this whole thing about instrumentality of private capital and this assumption that the public sector, that this vote would suggest that the private sector cannot do its job.
That's the whole point of redevelopment in the first place.
Would you be saying that if this was a non-condemnation redevelopment area?
I wouldn't bother.
And
I might think it, but there's no reason to come up and oppose it. Both the landowner and the municipality will ultimately benefit from the various financial instruments that the state makes available in that context. So it would not be in the interest of the landowner to oppose that.
I'm sorry, you're saying that the redevelopment without condemnation is a positive thing for the
In all likelihood, it opens up the door to financial instruments, pilots, RAB bonds, all kinds of things that you could do without threatening condemnation.
But you could also do them with the possibility of condemnation. The council could just
could.
choose not to do that.
You could.
Right.
But the question I was asked,
Right.
if
That's
condemnation wasn't on the table, would a landowner care? The answer is no, and he knows that.
And we wouldn't be talking about the fact that the board's determination that the area meets the criteria is some demonstration that the instrumentality of private capital isn't going to work here. That they have to conclude in satisfying the criteria that they have to. Now there's this new standard, right? That's not written in the law, in the New Jersey law. There's another standard in a federal law, statute, case law, whatever, that says if you're going to use redevelopment, you have to determine that government intervention is necessary.
Right.
You wouldn't be saying that if this was a non-condemnation redevelopment area.
Correct.
And there's nothing in the law that creates two different standards for condemnation and non-condemnation redevelopment areas.
Well, I took your first question as would I be here tonight saying it, not whether or not it's true.
Okay.
Yes,
Well, then answer both.
80% of the designation criteria are overreaching in D. They don't have the substantive evidence that the courts required in contested cases. But would it be a contested case without condemnation? No. So if you're asking me the practical question, would it be contested if it didn't have condemnation? My answer would be, it probably would not be contested. But if you're asking me if it's contested, do the things I say matter? Yeah, we just wouldn't bother saying them.
Right. But Malenga is a case of non-condemnation where an objector came and
Yep, it
had
happens.
things to say about
It
that.
rarely happens, but it happens. So I want to be careful. When I was answering your question, I was asking the practical question of would we be here,
Right.
not do I think what I said was true.
And to get to my second question, there's only one standard of what's a redevelopment area, right? There's not
That's true.
the additional Camp standard of condemnation redevelopment areas.
There is not.
Okay. Maybe one day. Maybe one day. And then, so my last question is, and I think it goes a little bit to Mr. Beal's point, I'm working on another Criteria B case, which miraculously comes under contract the moment that you do this, just like things get cleaned up the moment that a municipality does this. In that case, we were presented with a copy of the contract. Do you know if that happened here?
I don't know if I'm assuming it hasn't happened yet.
That's correct.
Okay. And you haven't seen it?
No.
Okay. So all of this is trust but verify.
Well, not necessarily, because we have a letter with requesting it be put off for 1 month, signed by the attorney for the buyer, saying that they want to discuss their vision for redevelopment for the property.
And that there's a contract, but we have no idea what the contract says.
Can I just pause for a second?
No, I'm good. I'm after this.
Yeah, okay then.
No, if you.
No,
I don't want
it's
to
a question, no, it's a
Answer the
question for
question
Mr.
that was posed?
Lechstein. Would it, thinking about the possibility of an applicant coming in to talk about that, I'm not sure I'm phrasing my question. What would it matter if they came in to tell us all these wonderful things that they're thinking about doing if we still don't have any proof that they're going to do it?
Well, one, it's to talk about, really to address.
And well, no, that's not Mr. Lechstein, but I agree with you. I mean, that was my point before. That's why I said it. It wouldn't make a difference to me if they were sitting here and they said, look, we just closed. Don't do this today because we're going to do all these wonderful things on the property.
And that would be a conversation to have with the governing body.
That's a conversation to have with the governing body, in my opinion, because it's not a conversation to be having with the planning board. The planning board doesn't devise development plans unless they're asked to do so specifically by a resolution of the governing body. That is the role of the governing body, not the planning board.
Right. So the question is a more practical one. Do we all waste time appealing this while that happens, or do we just wait until that happens so none of us waste time fighting on the litigation?
So now you're asking the board to make a political decision whether or not it's appropriate for this board to say, well, let's weigh whether we're worried about getting sued. So let's hold off and give you how long to determine whether they're actually going to buy the property or not. I mean, the argument's never going to stop. The argument's going to be 1 month they're in here, we close now. Okay, when's the work going to happen? We're going to get to it. It takes time. We have to do a lot of due diligence. We've got to get all these plans put together. So give us 6 months to do it. 6 months later, where are you? Well, it's going to take another month. How many times is this board supposed to not proceed with the conclusion of the report based upon the promise that someone is going to do something? I don't think it works that way.
In practical life,
Practical life.
it disappears. The report disappears and doesn't come back as long as people are on a proper timeline.
And does this board have the authority to make a report disappear that they've been asked to prepare by the mayor and council because they decide that they don't want to do it?
I'm not going to debate law with you. All I can tell you is my experience in life. That's often what happens.
That's fine, but you're the one suggesting it. And what I'm basically saying is I don't think this board has the authority to just ignore a directive of the council because it determines in its own infinite wisdom, well, we want to give the property owner a lot of time to do what they want to do.
Then the request that would be before you is move forward on the report absent the condemnation designation. Table that portion for 90 days.
I don't know. I don't think the board can do that. They have to make a conclusion.
I've watched boards do it.
Does it meet the criteria with
Right.
eminent domain, or does it not? And that's basically what they've been asked to
And
do.
we're stuck with our argument that it's not.
And that's fair. That's your argument.
So Mark, just thinking out loud. When we were presented with this last month, I was okay with condemnation. I've been to the property. I'm familiar with the property. I got here in 2001, right when you did, when you arrived. But being a good neighbor, living here, 2 decades, I've been afforded some grace in the community. And it's that, like, you're driving 35 and a 30, the cop pulls you over, he knows you're a local guy, he lets you go, even though he could give you a ticket by letter of the law, right? So I just spiritually don't have a problem with giving them 30 days, but I'm telling you, I do agree with condemnation. So I'm not going to change my mind, but unless something else happens in 30 days that's kind of miraculous. But I do believe the case was laid out for condemnation through 2 of the 3 areas, and
I mean,
I don't have a problem with that.
And Mr. Beal, that's fine. And ultimately, it's going to be up to the board whether it wants to decide. I mean, there's a couple of things the board could do. The board's heard a lot of testimony tonight. The board could vote tonight. The board could direct its planner to go back out to the site and view these things to see if things have changed at the site, that maybe they missed something. And the board's allowed to do that. It's the board's report. You don't have to just go by the report that was put together by the planner and here's your report. You got to take it or leave it. You could ask for more information from your planner if you feel like you want to ask for more information.
I hope I'm not putting too much pressure on you, Mark, but my point of the grace was to not, I can understand how stressful it could be to carry a multi-million-dollar property with not many tenants and you're almost ready to close a deal and then something like this happens. I wouldn't sleep good at night. And, being a citizen of the community, I would like 30 days grace if I were in his shoes. But I'm telling you, I'm down with condemnation, but I understand the 30-day request.
It's not my decision. I don't live in Ocean Township.
Can I
this is going to affect me either way, other than the fact I drive past this place every single day. And and
Can I say
hasn't
one
changed
thing
much for years.
also? Mr. Chair, is it okay?
Yeah.
And I want to address a little bit, and I respect what you're saying,
Right.
and I feel you. The appeal period, right, starts when?
45 days from the adoption of a resolution, which I obviously would not have tonight because of the fact that I couldn't do it tonight.
Okay, 45 days, the adoption of a resolution by whom?
By the planning board.
Not by the governing body
No, they can appeal.
designating the area?
No, they can appeal the decision of the they can appeal the decision of the planning board the moment the planning board makes that decision. So the planning board adopts the report, they could challenge the report on its own. They don't have to wait for the council to do anything.
And the council, and I've seen this is what Mr. Rayenkamp's talking about, disappearing reports. Councils may never act
That's
on
correct.
reports.
That is 100%.
I've seen that happen.
I've seen that
So
happen
I
too.
think if it helps folks sleep better at night, like there's a system set up, right? Where we all make narrow decisions at narrow points in time. People get notice. There's different accountability. There's different audiences, and it's all happening in public. And we're making a very narrow decision here. So in a voting on whether this meets a criteria, it's a very factual determination. It's a mixed question of law and fact, but we're applying a series of a legal criteria to the facts that we have identified on the ground at the time of the report, and that's what the vote is tonight. Not whether you should do this, not whether whatever. And there's going to be 45 days until there's a lot of time.
The board should not be making a decision based upon whether it's going to get sued or not, because
Yeah,
that's the wrong thing for a board to do.
Not worried about being sued.
With that said, you should worry about whether or not you feel comfortable with the report the way it is submitted today. You may. So if you need more information in the report, you should do so. If you want to follow there's nothing to prevent what Mr. Beal's suggesting. If he wants to do a 30-day extension, he can. I'm just saying it's not necessary from a legal perspective. It's the nice guy standard, which isn't part of the law.
Right. So again, I agree with condemnation. So you had me already on there. That's not my issue. My issue is it's just good manners. If we can give him 30 days, right. I plan on being here in 30 days. You guys do too, right? Yeah. I don't see what it's going to hurt.
You don't want it to be counterproductive.
Yes.
Right. And I'm going to give you some, I don't know if this is planning testimony or not, but I work with 25 municipalities. I've been doing this for 20 years on redevelopment in particular, and I would ask you to entertain the thought whether we would be here or not if condemnation wasn't on the table, whether they would be here or not if condemnation wasn't on the table, if as a standard, it's motivating to property owners. And yes, it'll be here and it'll be here in 30 days. But
Nothing's going to change in 30 days. That's what my point
Right.
is. Whether they sell or
The
not
ownership could change in 30
sell, that
days.
doesn't change the site.
yeah, this isn't personal.
Yeah, the report is not based upon who the owner of the property is.
You already had me on the report. I agree with you.
No, but my point is you're saying what's weighing into your mindset is
So,
whether the ownership changes.
I
But
can
the
add clarity to
site
that.
doesn't change.
I'm using a human touch. I own a bunch of rental property. I'm a realtor for 20-something years. I don't know who's buying this, but I'm assuming they have deep pockets. So them going through this versus, I don't want to call you mom and pop, but this gentleman, I think is a little different. So and I've already told you, I'm okay with condemnation. This is just a time thing.
Yeah, but Mr. Beals, but hold on. My hang up on all of this is that any path forward, including all of the possibly beneficial paths for whatever future owner through a non-condemnation redevelopment plan, cannot start, conversations cannot begin until we make our determination. So whatever the council decides to do after we make our determination can't start until we have this vote. And waiting 30 days, the new owner is not represented here. They might want to have a conversation with the council about a redevelopment plan. They might be counting on it. We don't know. We're asked to just look here, and I appreciate what you're saying. We gave them grace to have this second hearing so they could present their findings. And to be fair, I think this has been a really good, robust discussion on all of the issues. But
Of our better meetings.
yes, I agree.
I mean that in a good way.
Yes, absolutely, and I appreciate where they're coming from. But here's what I'd like to do. I'd like to see if anyone of our professionals or the applicant's professionals have any closing remarks, and then I would like us as a board to discuss this. Are we good with that path forward?
Yeah. Yep.
Briefly,
Good deal.
just real quick, maybe this might help streamline it a little bit. I have in my notes that there's still going to be some updates to the report itself. I'll leave it to Mr.
They're
Abrams.
going to have to be. I
So-
think, right? Because you're going to make some technical typographical changes. They're nothing substantial.
I don't necessarily agree with that, but
Well, it's up to them. I mean, they tell me.
well, if it's
There's been an assertion that some of the photographs are
make any
out of
sense.
date.
No. As of the date of the report, they're accurate. That's what we're going with. We're voting on the report that was presented to us. Whether or not things have changed on the site since then, they could change day to day.
But Mr. The question is, are there any typos within the report that have to be fixed? And if the answer is no, the answer is no.
so there's
So the report as it is today
Well,
is
hold on,
fine.
time out. Yes, there are. Based on my test, our conversation last time, there are non-substantive typographical errors that need to be updated.
Yeah, you found three.
Non-substantive.
I believe you found 3.
Yeah.
Right,
Yeah.
so there's some inconsistencies, a few hundred feet on floor or square footage, here and there. There was the bus stop concern, which was a valid one.
And impervious with the frontage.
Right, and the impervious, which we said was approximate, and illustrative. So,
I think it was listed as 2 different sizes in the report that he found. One page said one thing, another page said another thing.
It was a typo. It was a transposition of numbers.
And if that's all it is, those changes do need to be made. Okay, so they don't need to be made tonight, but if the board's going to vote on this, it has to be with the understanding that those changes are going to be made and submitted.
right,
The
so,
board wouldn't vote again on the report, assuming that's all we're talking about.
right,
Because they're minor typos.
right. These are Scribner's clerical type
Correct.
things. If you wanted to include them in the resolution, then I could include a revised report with the
I
revised
just
date.
all I would need if the board voted tonight was you're including those Scribner, you're gonna fix those errors, and that's your final version of the report. You can say that tonight, that that you're making those changes.
It would make no other changes other than the ones that we've discussed tonight.
that we discussed tonight. Because
Right.
what I'm getting at, just to be clear, is at the May 19th meeting, one of the comments, and I believe, Ms. Sheriff, it was from you, and I had it marked down, is they're missing one of the biggest things when they're talking about access. That was verbatim what you mentioned.
The bus
I-
stop.
I don't see that as nomenclature or typographical errors. So if it's,
Is this criteria age, which we've already talked about, is not sufficient to substantiate a blight designation on its own? I don't see that as core or heart to the matter at all. Like, he probably means maybe from a criteria age, smart growth, access, multimodal standpoint, but not about the site in general or about the findings or criteria in general.
Yeah,
Your report already said that it met the criteria for H anyways, absent the bus stop.
Right, and that's what my point is. It's either in the report or it's not in the report, and if it's not in the report, then it can't, it's not
be
part
relied
of the argument, because they're adopting the report with the addition of the typographical errors that are gonna be fixed. So the bus stop wouldn't be in there because it's not part of the report.
Bus stop out.
Yeah, but you can't put it in. That's not a typographical error. Unless the board wants the bus stop in there, which you can direct him to do and come back and see the report next time.
All right. Any other comments, Mr. Darrow?
no, I just,
Okay.
whether it was non-substantive or it was substantive change, if the board's going to rely on change in the report other than typographical
Right.
errors. and
That
it's gonna
would be,
Okay.
that would be,
So-
adding something like the bus stop would be a substantive change.
All right.
If we're not going to add it, then we're not going to add it.
Okay. All right. Board members, we've heard a lot tonight, and I think we all have some thoughts and opinions. So let's discuss. Mr. Adis, you have something?
I think so. But I think that I think intent matters, and I think the report maybe can justify based on vacancy and some maintenance that it meets the criteria for condemnation. But I think as far as the vacancies, they're there. We heard that they're there because it makes it easier to redevelop the property, not more difficult. I think we didn't see any. No one was inside, as they talked about. No one was inside the property, showing the dilapidation, and also that I think maintenance again was intent. Once it was shown that there was maintenance required, there seemed to be some reaction to that as quickly as possible. So I'm going to vote no on the condemnation, and if I have to vote yes or no, I think it's no because I can't vote for just the redevelopment. I think redevelopment is a no-brainer, but I think I will be voting no on the condemnation.
So, Mr. Adis, I understand what you're saying. I disagree. I think for me, it is the vacancies. All three criteria, I believe, have been met. Our planners demonstrated them. I think that the vacancies alone, the history of the vacancies, the testimony we've heard tonight that the vacancies aren't even necessarily accidental. They were intended. I think that our planner has demonstrated that all three of these criterias have been met. I'm concerned about the stormwater basin and how it impacts the town's MS4 permit. I'm concerned about a lot of it. I think that if some of these major infrastructure issues in the stormwater basin, I haven't been out to see what was done to it, but it is hard for me to believe that based on just the age of the basin that it has been restored to its original infiltration rates as designed. Barring an engineering report seeing that, I cannot accept that it has been repaired to a functioning status. So I think that we've been asked to see if this report meets the criteria for condemnation redevelopment, and it's going to be up to the council to decide what to do with it. But I've seen enough. I think that it meets all the three criteria.
And we should emphasize that this is not one of these cases where it's not the preference of the board members whether or not they feel, use condemnation or not use. I hate condemnation. That's not the standard here. The standard here is whether, as the chairman just said, has your planner, it's your report, has your planner demonstrated to you that the criteria has been met? If the criteria has been met, you're obligated to vote to accept the report as written. This isn't a preference, and I just want to make that very, very clear to the board.
Yeah, and unfortunately, Mr. Adis, we're not taking two votes. We're taking one. It's either we accept or we send it back to the council for condemnation redevelopment or not. There's not going to be a mix and match there. So, does anyone else have thoughts, comments they want to share? Mr. Mamie.
So, to your point, our planners were not able to get into the building to see the interior condition. But part of that was because we noticed him and tried to reach out to him, and and received no response. And you claimed at last meeting that you had only found out that day about this whole redevelopment action. So, I mean, I think that speaks to a history of, you know, just maybe not keeping up with the property properly. And, you know, I'm in and around a lot of people who are involved in real estate, and they all maintain their properties in different ways, and usually they check on the sites regularly, and they say, oh, this, you know, and also they have maintenance people constantly going in to fix air conditioners or, you know, do other types of maintenance, and usually those people say, hey, this other thing needs to be addressed at the property, maybe you should look into that. And those things are taken into consideration. So I think that, you know, yes, it meets the, you know, criteria for redevelopment, but also it, you know, all that speaks to, you know, just the general state of the property and how it's managed.
All right.
Yeah, I'll just add to that. So obviously I'm on both teams right now. That being said, I think we do have to remember what Mr. Lechstein said, which is that we have to speak to what's going on the property today. That being said, as an ancillary point, we haven't seen a contract. We've been hearing rumors of, you know, buzzing about what's happening on the property for a year, for more than a year. And the fact of the matter is, right now, today, criteria B is met, criteria D is met, and criteria H, while not standing alone, is determinative. It adds to the overall evaluation. Thank you.
All right, anyone else have anything they want to share with the board?
So,
Mr. Beal?
so to be clear, I could vote for redevelopment with condemnation next month. Tonight I can't. I'm looking at it, fellow, you know, Spartan there, and he's asked for a 30-day reprieve for reasons I uniquely understand. And I'd have no problem coming back next month. We could talk for 3 seconds, and I'm yes, vote for condemnation. Today, I cannot support that, and I just don't see the rush of why 30 days that someone's asked that has been here for 21 years and has been a good citizen, a taxpayer, just asking for 30 days. I don't see the problem, but I agree our planners have met the burden. I agree the property is categorized properly for redevelopment with condemnation. I'm not arguing that. I just think 30 days is not much to ask for. Because that's all you ask for is 30 days, correct?
Yep, with the consent and request of the buyer's attorney.
That's where I'm at.
And I think they could ask those 30 days at the council. And I think that they could have a really good, robust discussion with the council when it comes to developing the redevelopment plan. And I'd rather see that process.
So you're absolutely right. So two things can be true at the same
Yes,
time.
sure.
I want to be clear here.
Right.
I know that. What he is not actually saying, but I'm saying on his behalf, if you let me, if we move forward tonight, it could affect his sale. And that's a terrible place to be in. That's what the 30 days is for.
No.
Listen to your lawyers.
All right. I think, does anyone else have anything they want to say? All right. I think we're about that time. It's time to make a decision on where we go forward. Does someone want to move a resolution here?
I'll move.
You're making a
To approve.
Well, it's not the resolution. You're moving to adopt the report. I'll prepare a resolution at the next meeting.
Okay. I move to adopt the report for economic redevelopment and condemnation.
And I'm going to second that. So, Nicole, can we have a roll, please?
Councilwoman Kaplan?
Yes.
Ms. Valente? No. Mr. Beal?
No.
Mr. Davis?
No.
Mr. Mamie?
Yes.
Mr. Goslin?
Yes.
And Chairman Ophelia?
Yes.
So what was that? Four yeses, 3 no's. All right, so the report is adopted. I'll have a resolution at the next meeting memorializing it and sending it on to council.
All right.
Thank you for listening to us.
Yes.
Thank you for your time.
Again, and I appreciate the conversation. This was not something this board does often, and I appreciate you taking the time to present it and dialogue with our planner, and I wish you the best of luck.
Thank you. Next meeting resolution?
The
All
next,
right.
the next meeting will have the resolution, yeah. It's not gonna be an extreme resolution. What is the next meeting, July 10th?
We could have moved to the vote. Okay, okay. This was a good meeting, though. I was finally like, yeah, all right, this is good. This is good. I agree. But the guy's just asking for 30 days. It's not going to kill us. That's all I'm saying.
July 28th.
The thing, like,
All right. So I have a motion to adjourn this meeting.
Motion to adjourn.
Moved by Ms. Valente, seconded by Mr. Adis. All in favor? Aye. Thank you.
It's the next meeting, by the way,